Well, be careful what you say. And it's not your fault.
Oh, I know it's not my fault.
It's not your fault. Quit laughing.
All right. Record should reflect at a bench conference in this case. Really, there's a motion by the people to modify his bond.
And that's correct, Your Honor. It's our understanding that this case was picked up while the defendant was on bond for another case involving controlled substance delivery and manufacturing, as well as probation in circuit court. And I believe per the statute, he should have been given a surety bond. So this time I would be re-requesting our original request of $50,000 cash surety. However, I understand the court. Thank you.
And Your Honor, we do understand the people's concern as well as what the statute states. However, my client has been out on bond on this case with absolutely no issues. We know that there is another case. He was present for his preliminary examination on Tuesday for that matter. I believe that the issue of bond was addressed at that time and the judge put him on a home confinement tether GPS. That was Tuesday. He does have that tether on to my understanding. Yes, there may be a violation. It has yet to come up in circuit court as of now. However, he's been doing everything he's supposed to do on bond, Your Honor. So I'm asking that the court, if there is a requirement to put some type of cash component, make it as minimal as possible to allow my client to continue complying as he's been doing.
Right. I would find that the setting of a personal recognizance bond under the circumstances was use of discretion by the magistrate. Setting bond. I am going to take into account the fact that, yes, it should be some type of surety bond, but I'm taking into account that, as defense has indicated, he's been doing what he's supposed to be doing, other than picking up this case while he was on bond on the other thing. But since that point, he's been cooperative. He's been doing everything. So I'm not going to require what the people had requested, and not necessarily a surety bond, but I'd be looking at it this way. I'm going to set his bond at a 10% bond in this matter. At least that way he can post it. I will also set the, you want this set for preliminary?
Yes, Your Honor, please.
And your discovery is complete?
To our knowledge, Judge.
All right, discovery being complete. Would the people have their witnesses available the 17th?
Double check on the. We are just waiting on the final call.
Pardon?
I requested the 911 call, but I have not received it yet.
Okay.
We're fine proceeding.
You're willing to proceed?
That's right, Your Honor.
All right. Preliminary examination in person, March 17th, 2026. 9 a.m. before Judge Moore. All right. I'll set his bond. Defendant is remanded.
Thank you, Judge.
Thank you.
This is a classic bond modification dispute, and the judge is balancing two competing considerations. The prosecution emphasizes that the defendant allegedly picked up this case while already on bond and under circuit court probation, circumstances that significantly weaken any argument for continued personal recognizance release. The defense, however, narrows the focus to his conduct after this new case began, appearing for court, accepting GPS home confinement, and otherwise complying. That strategy gives the judge a reason to reject the prosecution's much harsher request for $50,000 cash. The resulting $10,000 10% bond requires a potential $1,000 deposit, creating a financial consequence without making release as difficult as a full cash bond. Did you notice that the judge acknowledged the alleged violation, but still credited the defendant's subsequent cooperation? That does not erase the new allegation. It simply shows that bond decisions involve risk management rather than punishment before conviction. The final remand language means he remains in custody unless and until the bond is posted or otherwise clarified. The larger question is whether his recent compliance genuinely predicts future behavior or merely follows the filing of another serious case.
Kareem Johnson, on behalf of Mr. Poole, this is the co-defendant case, Your Honor.
Yes. And
He's going to be
the next in. Your name, sir?
I'm cool.
All right. What are we doing on this?
Your Honor, we're setting this for exam, and I would like to address my client's bond.
Who has the co-defendant?
Mr. Burgess, that's.
Is that going to be the same position on?
Saying it for examiner?
Yes.
That's correct.
All right. And Mr. Johnson, you're not available the 17th.
That's correct, Your Honor.
All right. So I think I said his other matter for the 31st when we looked at dates. Will that work for you, Mr. Burgess?
That's fine.
Is that okay? So what are the numbers?
I updated your shift for the 31st. You've got to Washington.
Well, we'll just start loading her up at some point. I'll set preliminary examination in person March 31st, 2026, 9 a.m. before Judge Washington. All right, as to bond.
Yeah, my client does have significant family support. His mother, his brother have been in constant contact with me. He does have a place to go and responsible people to make sure he will abide by any bond conditions. We concede that allegations made in this case are serious. However, I don't believe, other than a picture taken over an hour after the incident, there's no electronic, scientific, or personal identification that places my client at the scene of this crime, conducting any crimes, Your Honor. So because of that, we'd ask for a significant bond reduction to $15,000 cash, surety of 10%.
Current people would object to any change of bond at this time. The basic allegations here is that the defendant, along with the co-defendant, fired at an occupied house. My understanding is that that house had previously been occupied or owned by members of a rival gang, and that this was a gang-related shooting. The members or the individuals in that house were not really with that gang, completely innocent, my understanding. But the defendant, the co-defendant, fired, I believe it was 25 rounds into or at that building, including some of those rounds being fired by a fully automatic weapon, some of those rounds being fired by a rifle. I have significant concerns for public safety. If the defendant is to be released now, to ask that bond remain as set.
I guess the only concern that I had is Mr. Johnson indicated there is evidence that connects this defendant to this crime I'm preserving.
Yes, it's a lengthy report. I can go through and try and find exactly what evidence that is, but I can have just a second.
Well, that's okay. It's just, it made it sound as though there's no evidence that connects this individual, but that's not what the people's position is.
Correct.
At this point, given that exam would be pending, I'm going to deny the request for a change in bond. Bond will continue. All right.
Yes, sir.
Thank you. Thank you.
This is the strongest evidentiary conflict in the hearing. Defense counsel argues that, aside from a photograph taken more than an hour later, there is no electronic, scientific, or eyewitness identification placing this defendant at the shooting. That is a strategically important attack because it separates the horrific nature of the incident from the question of whether this particular defendant committed it. The prosecution responds with allegations of approximately 25 rounds fired into an occupied house, including gunfire from a fully automatic weapon and a rifle, but cannot immediately identify the specific connecting evidence when the judge asks. Does that hesitation damage the prosecution's presentation? It certainly leaves the judge without a fully developed evidentiary explanation, but this is a bond hearing, not the preliminary examination where probable cause will be formally tested. Judge Simpson therefore preserves the existing bond rather than effectively deciding the identification dispute in advance. The defense established family support, housing, and supervision, yet those release factors were outweighed by the alleged danger to the public and the unresolved evidence described in a lengthy police report. Would you reduce bond before seeing that report tested in court? The pending examination now becomes crucial because the prosecution must connect this defendant to the gunfire, not merely prove that a terrifying shooting occurred.
Court calls case People versus Willie Collins.
Morning, Your Honor. Raymond Cook for the people.
On behalf of Mr. Collins, Your Honor, did you get my green sheet?
I did.
So we're requesting an adjournment.
That's to go. I've got it. I have a violation, however.
Yes, I shared it with him.
How come he hasn't gone?
Your Honor, there was some miscommunication when he was released. And he has a plan now. He lives on Berkshire. He has a plan so that he can, and he'd be clean today if we were to test him.
But he hasn't been over to test.
Well, he knows where it is now.
But he didn't know before?
No. He just said he didn't know where it was, Your Honor.
Well, why didn't he find out?
Well, be careful what you say.
I mean, he hasn't tested at all.
Well, he'd be clean right now.
Well,
Today.
but he hasn't tested at all while he's been on release.
That was from what, the 24th. So it's not like it's a couple months.
So he just didn't go.
Well, he didn't know. That's my information.
He didn't know what?
That he was supposed to go. Well, be careful what you say.
Your Honor, when I was talked to by the magistrate, I just got Jackson County doing a year. I'm on probation in Jackson County. So the magistrate told me that I can test when I go report. I just reported Monday.
He told you what?
That I had to reply with Jackson County's probation.
Comply with Jackson County probation. He means, I think he has tests as a condition of his probation in Jackson County. So Jackson County.
I don't have any record of that. No, it's written over.
That's what he's representing. His information and belief was when he was arraigned that he could substitute the testing in Jackson here. That's all. And there was a little miscommunication on his part. So
but he hasn't. Have you tested in Jackson?
Yes, sir. I just
When?
Monday.
When?
Monday, sir.
he'll sign a release right now if you want.
Well, he needs to get over there and do all of that. But I'm not going to have a circumstance where we tell him to test and he hasn't even gone over there and reported.
But he's testing at another.
He hasn't reported and hasn't been in contact with our community corrections.
Well, he's prepared to do it right now. He's just being double dipped, testing two places. That's all. And it's not your fault.
Oh, I know it's not my fault.
It's not your fault. Quit laughing.
March 26, 2000. I'll set his adjourned probable cause to March 12, 2026 at 9 a.m. But at this point, defendant's bond is revoked. Defendant remanded.
Now he's going to get in trouble in Jackson.
I didn't do it. I just did my job.
The final hearing demonstrates why bond compliance is judged through documented conduct, not assurances about what a defendant would test clean for today. The defense presented the failure to report locally as miscommunication. The defendant believed testing through Jackson County probation could satisfy the requirement here, and he claimed that he tested there on Monday. But Judge Simpson repeatedly returned to the central problem. He had not reported to the local community corrections program, had not established contact, and had not completed the testing process ordered in this case. The defense's offer to sign a release and verify the Jackson County result was useful, but it arrived only after the court confronted the violation. The remark that he was being double-dipped also risked minimizing the court's authority. Separate courts can impose separate conditions unless one court expressly approves a substitute arrangement. Did you notice the judge's warnings to "be careful" and the immediate correction when laughter entered the exchange? In a bond proceeding, that kind of reaction can appear dismissive when the court is evaluating reliability and willingness to follow instructions. Across these hearings, Judge Simpson used progressively different responses: a financial bond for a defendant showing some cooperation, no reduction where a dangerous shooting allegation and disputed identification remained unresolved, and complete revocation where compliance could not be demonstrated. The broader lesson is simple. Release conditions must be clarified immediately, followed exactly, and verified with records, not assumptions. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.